Hello, and today I want to look at the criminal offence of murder, and I want to cover all the elements of the actus reus and the mens rea, and for this reason the video may be slightly long. So the actus reus consists of 6 key elements that we need to talk about, which is unlawfully causing death of another human being under the Queen's peace, as long as it abides by the year and the day of rule. So, what do these things mean? Well, the idea that the killing, the homicide, is unlawful refers to the idea that there's an absence of defense, such as self-defense. And do note, mercy killing is not a defense either, it is illegal. So the case of English 2010 makes it pretty clear you cannot use that as a defense. It is still unlawful, the killing. The second element of the actus reus is the fact that death must be caused. Someone must be killed. And the normal rules of causation will apply, but there's a further issue that we must keep in mind. Where a life support machine is withdrawn from the patient, this will not be deemed to be causing death, because this counts as an omission, and there's no responsibility for the hospital, because they just have a duty to provide the best medical treatment. And if the life support machine is no longer the best medical treatment, they have every right to withdraw it. And this is made clear by Airedale, NHS Trust and Bland 1993. The third element of the actus reus has to be the idea that is of another human being. Now this is perhaps the most troublesome part of the actus reus, because prima facie, we think that it's pretty straightforward, another human being has died, but there are issues revolving around the beginning of life and the end of life. So if we talk first a bit about the beginning of life, we're talking about a fetus here that's been killed. So the old law, as per Handley in 1874, states that, the fetus must be able to independently exist, independently of the mother breathing through its own lungs. And this was held as compatible with Article 2, right to live, with the European Convention of Human Rights in Vaud and France 2004. And then in Attorney General's reference number 3 of 1994 in 1997, it was made clear in this case that murder applies to actually a live baby that's living independently of its own lungs, because they use a conviction of constructive manslaughter, arguing that over there it's not required that the death be of another human being. So they applied constructive manslaughter. Then we're looking at the idea of end of life. So this is assisted suicide. So first point to note is that suicide, generally killing yourself, is not illegal in England and Wales. So let's begin with the first case of Malcharek 1981. This is the case referring where it was talking a bit about a victim being kept alive in a life support machine, and the Court of Appeal here, they did not exonerate the defendant, and they were happy to say that turning off the life support machine does not affect the chain of causation. So you cannot argue that, similarly to as we were looking at the beginning at unlawfully. Then you have Airedale, NHS Trust and Bland 1993, which confirms this decision. And then you have the next case, NHS Trust A and M 2001. Here, the hospital sought permission to discontinue artificial hydration and nutrition to a person who had been diagnosed in a permanent vegetative state. The court noted that Article 2, right to life, imposed a positive obligation to give treatment, but they noted that this was where the treatment was in the best interest of the patient, not where it would be futile. Therefore, discontinuing the treatment would not be an intentional deprivation of life under Article 2, and provided that withdrawing the treatment was in line with the respected body of medical opinion, and that the patient would be unaware of the treatment and not suffering, so they would not be in breach of this right, so it was allowed. Then moving on to the case of R. Pretty and DPP 2002, the court here said you have no right to assist someone in killing themselves. They even went to the European Court of Human Rights and it was upheld that what the House of Lords said was right, and it fits under the margin of appreciation. This is also shown in R.B. 2002. She asked the hospital to turn off the ventilator, and the hospital said no and went to the High Court. And then I think this was the case where she wanted to... no, this isn't the case where she had a mental competency issue, I don't think. But anyway, I think the bottom line of this case was that a hospital could admit treating her. They were allowed to. So all these cases are basically saying the same thing. And finally, you have the case of R. and Purdy, DPP 2009, where the woman wanted to go to Switzerland with her husband to kill herself, and she basically brought a case to the court saying that the DPP they were under an obligation to clarify their position, and as a result, the DPP did formulate a policy, but it's still not pretty clear cut, and we don't really know, like whether in what situations killing will be allowed. We just know that turning off the ventilator does not break the chain of causation and is allowed, and assisted suicide and mercy killing clearly seems to be criminal. Then the next element of the actus reus is under the Queen's Peace. This basically refers to the idea that anyone in the UK except enemy aliens during wartime are protected by the law on murder, and British nationals overseas are also protected by the law of murder. Actually, now we're getting to the final point of the actus reus. At the beginning I said there were 6 elements to the actus reus. What I really mean to say is there's 5 elements to the actus reus. And that is the idea of year and a day rule. So previously, there used to be a rule for murder, that the murder had to occur and be taken to court within a year and a day of the actual homicide. However, the Law Reform Year and Day Rule Act 1996 has abolished this, and if 3 years have lapsed since the homicide, then the Attorney General can consent for the case to be taken up to the courts. So that's the actus reus in a nutshell, and now we move on to the mens rea. The mens rea for murder is simply malice aforethought. Now, what does this mean? Well, firstly, I think it's pretty misleading in the sense that malice requires no planning or premeditation or, wanting ill as such prior to the act beforehand. So that's misleading. And the second point is transferred malice, where you want to kill one person but you end up killing another, and general malice, where you just intend to kill a bunch of people like a terrorist account, do count as the mens rea for murder and count as malice aforethought. So what malice aforethought translates as, which we get from the case of Cunningham, 1982, and Vickers, 1957, is the idea of the defendant must have the intention to kill or cause grievous bodily harm. So let's start with intention. Intention for the purposes of murder, you have direct intention, which is the aim or purpose of the defendant, but we also have oblique intention, which is made clear in the case of Woolen, 1999, which basically states that was the grievous bodily harm or death a virtual certainty, and did the defendant realize this was a virtual certainty? If those two answers answer yes, then we can say that intention was present in situations where you may not be sure if direct intention was present. And when we look at GBH, we're looking at the normal thing that grievous bodily harm is really serious harm or injury. It could even be where somebody shoots the kneecap of somebody else with the infection, they die. It could still count because that shooting of the kneecap is a serious injury. And this is made clear in the case of DPP and Smith, 1961. Thank you for watching.